think with our...
Oh, Mr. Walter, I'm
Yeah.
sorry, Mr. Evans reminded me that we need your introduction, so I apologize. Can we start on this side of the room, please?
Todd, no, sir.
Oh, Todd Sherwood, Assistant Municipal Attorney.
Bill Paulson, Municipal Attorney.
Forrest Dunbar, Anchorage Assembly.
John Weddleton.
Pete Peterson.
Bill Evans.
Ellie Rick Johnson.
Derek Franny.
Julia Tucker, somebody, and folks in the audience, please identify yourself.
Robert Harris, CFO.
Thank you, Mr. Is anybody on the line? Nope. Continue, Mr. Paul.
All right, thank you, Madam Chair. So I think we have worked through our technical difficulties, switched projectors. The focus of today's meeting is the Open Meetings Act. I want to give you a quick tour of what the state law on open meetings requires, what municipal wrinkles have overlaid that, and warn you in advance that you're going to be subjected to some recycled materials that I had from private practice. Back when I was asked to give a presentation to the Association of School Boards, I'm told by the attorney I was working with that it had to be circus themed. So there will be circus themed slides before this meeting is all over. So I have given to each of you a packet of information. There's a single page that shows an Anchorage charter requirement, the Anchorage code requirement, a stapled page which shows the actual state law, and the final single page, not stapled, which is the state policy regarding open meetings. The policy is actually pretty short, and it is not bad to run through that verbatim. The policy of the state of Alaska for a very long time has been that governmental units exist to aid in the conduct of the people's business. It is the intent of the law, the open meetings law in particular, the action of those units should be taken openly, and that their deliberation should be conducted openly. So it's not just the official actions that the assembly is taking, but everything that leads up to the official actions as well. And then the policy is rounded out with somewhat different language. People in the state do not yield their sovereignty to the agencies that serve them. People in delegating their authority do not give the public servants the right to decide what is good for them to know and what is not good for them to know. And the people's right to remain informed should be protected so that they have control over the instruments that they have created. That's the broad policy, but how does the rubber really meet the road? Under the state law, all meetings of a governmental body, of a public entity of the state, are open to the public except as further provided. In that section, governmental body means an assembly or other similar bodies. And it also includes members of a subcommittee if the subcommittee has at least 2 members of the larger body on it. This ends up causing mass confusion about what it means for how many people have to be convened for a meeting to be occurring for open meeting purposes, but hopefully we step through that. What is a meeting then? So you are an assembly, you are covered by the act. The official subcommittees of the assembly are also covered by the act. What is a meeting of the assembly? It is any time that more than 3 members or a majority are present, whichever is less. So for your purposes, 4 of you gathered together at a session in which a matter in which you are empowered to act is considered by you collectively, it is a meeting. I would say then the wrinkle with the subcommittee would be if the assembly created a subcommittee that consisted of only 2 members or only 3 members, if a majority of that subcommittee was meeting to discuss something on which they were allowed to opine, that would also be a meeting. The consequence of all this law is that anytime 4 assembly members are getting together to talk about something that the assembly can act on, that will be a meeting that should be noticed and meet all the other requirements as well. And that's the other part of this arrangement, is that reasonable public notice is supposed to be given for all meetings required to be open under this section. So now we are entering the circus theme slides. At the Association of School Boards, I was asked to give questions which would be not intuitive and which would maybe highlight some of the squirrelier aspects of the law. So these will be totally unfair questions designed to ask you about things I have not yet told you about and that you may not be able to properly guess. But,
Mr. Paul,
yeah.
Forward a little longer, please. Thank you, Mr. Chaney.
Mr. Falsey, the information you're just given us. Let's say I send an email out and I've got 5 assembly members on that email. Is that what a Raleigh Open Meetings Act?
my sense on that, and my take on that would be, if you are sending an email that has 5 other assembly members on it, and you are engaging in deliberations where you are showing where you're coming from, offering advice, offering
As in your
decisions,
opinion?
then I think that is a deliberation that is supposed to be part of a publicly noticed meeting. Now, the consequence for that we'll get into before we're all finished.
Thank you, Mr. Kramer. Mr. Dunbar?
Bill, is the state legislature exempt from this?
Yes.
Okay, that explains it.
Yeah, I think if, I don't have a chapter and verse, but the staple page has a long list on page 2 or 3 of things that the Open Meetings Act does not apply to. They include juries, courts, quasi-judicial bodies, and I believe the legislature is one of the groups that is completely not.
For what it's worth, they've exempted themselves from the Public Records Act also. Not legislative agencies, but the legislators themselves.
Cool. It's good to be king. So, the circus team slides give you 5 Open Meeting Act spectacles, 5 scenarios to view as a surprise. Each one will end in a question, which I split the question confusing back and forth. Does this action, which I will describe to you in this scenario, deserve your cheers or jeers under the Open Meetings Act? So, number 1, we're going to the big top. We're stepping in. The first act we have on stage is the magically appearing assembly chair. Here's our scenario. Open Meetings Act is designed to allow the public to watch members of the board deliberate and vote on agenda items. The assembly just reorganized itself using secret voting and cloakroom discussions. Much to the public's surprise, a new assembly chair is revealed at the first regularly noticed assembly meeting. Does this board deserve your jeers? Question is yes or no. I'm not betting exactly what you want to put mine on yes or no. The perhaps prudent answer is no. That is not a violation of the Open Meetings Act because the Open Meetings Act expressly does not apply to votes to organize a body. And that's actually mirrored in the municipal code where all votes that the assembly takes are by roll call, except the vote to select a chair, which is, the secret. So that's scenario 1, the magically appearing board chair. So this is probably not.
Should be an open vote. I like it better than an open vote.
It is within the assembly's power to change that code.
I was gonna say that it was a lot cleaner that
Excuse
way.
me, gentlemen, this is a work session.
Sorry.
Thank you. Please continue.
All right, moving to our next circle in the ring in the circus. We're going to go to the Cannonball Fast board meeting. Here is our new scenario. It is Wednesday. The school board district superintendent just submitted her resignation effective immediately. The school board wants to meet ASAP. The board notices an emergency meeting for Friday. Does the board deserve your jeers? Is this verboten under the act? The answer, again, is no. And that is because notice has to be reasonable under the state act. No rule sets a hard minimum. The Anchorage Assembly has set for itself a hard minimum of 24 hours notice for any special meeting, although it could be an emergency thing to that. I'll have to look into that now that I've said do this again. And here's where there's a little bit more to say, that the case law that has developed around the requirement that notice must be reasonable suggests that the assembly has to give, and other public bodies have to give, more notice when the issue is more significant, and that the notice should give a concerned party enough time to be involved in the deliberations. The notice itself has some requirements, as say the time, date, the place, information about teleconferencing, and what you're going to be talking about, which is why our special meetings always tell you the topic. Now, the case law that I mentioned largely turns on this Tunley versus Municipality of Anchorage School District case decided way back in 1980. And there, the case turned not on the Open Meetings Act, but on a provision of the Anchorage Municipal Charter. And this is also in your packet materials. Our charter says all meetings of the Assembly, the school board, and other boards and commissions are public. The Assembly, by ordinance, shall adopt procedures for maximum reasonable public notice of all meetings. So the factual scenario in Tunley was the school board wanted to close several schools, and they noticed a meeting for 5 days in the future in which to take action on whether to close the schools. And the Supreme Court, I believe Justice Rabinowitz said, no way. 5 days is not sufficient time to appropriately prepare an opposition concerning an issue of this complexity and importance. And they made the assembly, the school board, go back to the drawing board. Ultimately, the remedy was they re-noticed the meeting to occur 3 months into the future, And that seemed to pass muster, or at least no one challenged it. So we're left with, at least under the municipal charter, where we have to give maximum reasonable public notice. No one knows precisely what that is, with a single exception that if you want to close the school, it's got to be over 5 days.
But did they close the schools?
I don't remember. I think they did close.
No, it's too late summer.
I'll have to look into the answer to that. I don't really know the answer. All right, so that was our second scenario. Returning back to our first circle, now we have the Work Session Contortion Act. Our third scenario to the light in the maze. The on-again, off-again school district has work sessions instead of board meetings every other week. And the board doesn't provide public notice of those work sessions because nothing happens at them, no official action. The one time the board tried to take action in a work session by voting to go into executive session, the board president prohibited it. Is that all okay under the OMA? Yes or no? Do they deserve our cheers? Maybe intuiting that I only made one slide that always says no, so the answer is always no. I think the answer is always no. No. Work sessions under the Open Meetings Act are meetings like any other meetings. And in the school district context, this is actually something of a surprise to folks because the school districts tend to think of work sessions as being a beast completely unlike a regularly noticed agenda meeting. That is not the Assembly's practice, and the Assembly is doing it correct. Under the state law, there are no kinds of meetings. There are only one kind of meeting. Under our code, we distinguish between special meetings, regular meetings, work sessions, executive sessions, but they all fall under the penumbra of meetings of the state law.
Mr. Paulson, can you pause a moment? I'd like for the record to reflect that Mr. Cross is joining us in this work session. Please continue.
Work sessions should be noticed and conducted like any other meeting. They're open to the media. They can be recorded. And then the one exception to how these open meetings work, the exception is executive sessions. And we're going to step back into that in our fourth scenario. I'll also do the record. I think Mr. Croft was subjected to this presentation at that school board meeting once upon a line ago, so this is old news for him. Our fourth scenario, the executive session pantomime. Here is our scenario. The Assembly is asked to go into executive session to discuss two issues. A sensitive personal issue involving allegations against a career employee, pretend there are two extra E's there, and a plan to save money that can involve laying off several employees. The career employee objects to executive session and wants the allegations against her aired publicly. And the board goes into executive session anyway and discusses both issues. Is this one okay? Because I was lazy and only made one version of this slide, the answer is no. And the answer is no for two reasons. Executive sessions under both the state law and municipal code and the charter are permissible only for very limited reasons. Here's the black letter law. The following subjects may be considered in an executive session under the state law. Matters the immediate knowledge of which would clearly have an adverse effect upon the finances of a public entity. Subjects that tend to prejudice the reputation and character of any person, except that the person can say, I want this out in the public. So if you say, we're having this executive session because we don't want to embarrass Forrest Dunbar. Forrest Dunbar can say, bull, I want to have this out in the public.
It's been a trial by court martial.
Right. Matters which by law, municipal charter, or ordinance are required to be confidential, which actually gives the Assembly something of a safety valve to expand the provisions of the state law. And matters involving consideration of government records that are not subject to public disclosure. What have we done as a locality? This is also in your Assembly packet information I've passed out. The Assembly can call an executive session, and we just modified this a little bit to make it more in line with the state law requirements, because the state law requirements do confine us in some ways. So we've now said that we can call an executive session for a specific legal matter, including pending litigation. That actually is related to the state law because the state law says the only action you can take in executive session is to give an attorney direction on pending litigation, which must mean that you should be able to call an executive session to discuss pending litigation. We have said labor negotiations with municipal employees are things that we can talk about in executive session. That takes advantage of that book that we can expand it slightly. And then the rest of them track very closely. Matters the immediate knowledge of which would clearly have an adverse effect upon the finances of the municipality, subjects that tend to prejudice the reputation and character of any person, provided that the person may request a public discussion. Matters which by law, municipal charter, or ordinance are required to be confidential, and matters involving records that are not subject to public disclosure.
Mr. Middleton?
So in that case, so if an individual being discussed says, I want it out in the open, we're required to do it in the open, or is that, sounds like we got the option?
I I think you would be required through the chair, and the reason I think that is because while we might create any kind of rule that we prefer at the local level, I think the state law is clearly set up that way to say we can hold an executive session to protect the reputational interest of the person we're going to talk smack about. But if the person wants to have that all in the air, that's their right. That they can say that I'm willing to have all that dirty laundry protected, and then we can't sort of paternalistically say it's better for you that you talk about this secretly.
There's nothing to protect anymore. They have said it isn't. Yeah.
And the state law trumps us. Where the state law is speaking very clearly about what the rules of the road are, I think we are obligated to hew closer to the state law.
Thank you, Mr. Middleton. Mr. Cross?
Oh, I'm sorry, I didn't know you wanted that level of formality. I apologize. The state law says anything that is required to be confidential, and then our ordinance says these things may be confidential. So in order to expand in that hole that the state law gives us, don't we have to require rather than permissively allow?
Well, I suppose that is a great question through the chair. Maybe if we have an executive session to talk about labor negotiations, someone could say, well, you tried, but you didn't quite get over the goal line because you allowed yourself to talk about them confidentially, but not require yourself to talk about them confidentially. It's never been tested. Maybe we should have written it differently, but I think we would be okay in that world. So the scenario that we began with was that we were going to talk about one employee who we wanted to fire because of whatever reason. She's allowed to say that I want to have it in the open session. We were also going to talk about a controversial way of saving money, which is going to involve lots of layoffs. That is almost certainly not enough to get you into the executive session, just because the idea is going to be controversial and could eventually have a budgetary effect. That's not going to get you into any of the executive session codes. It's really things that if someone knew this information immediately, they could harm municipal finances, either because we're saying this is the amount of money we would settle a lawsuit for, or we're about to make a big purchase, or something that someone had sort of insider trading knowledge of that they could benefit from or harm us with.
Mr. Boston? Any further comments? Thank you. Ms. Tucker?
Policy to the chair. I didn't bring my copy of the charter. Does the charter address, regard to the municipal charter address? I'm thinking that you and I had a conversation, that I don't know we ever got to the conclusion about, but it was related, mainly related to what Assemblyman Cross brought up. But I think that the question was, what did our charter go farther than the state law did? So that where state law trumps charter, the charter can always be more restrictive than state law. And do we have any wiggle room in there? And we sort of left it open. I can't remember how that.
Yeah, through the chair, there is a slight mismatch in the language of the statute and the language of our charter, which is much harder to monkey with without going back to the voters. But in 1975, our charter said, and this is on the section 1705A, which everyone has in front of them, in the middle of the paragraph, an executive session may be held to discuss any litigation or any other matter, immediate knowledge of which would tend to adversely affect the finances of the municipality, or to defame or prejudice the character or reputation of any person. The general matter for consideration in executive session should be expressed in the motion calling for the session. No official action may be taken in the executive session. So you have three organs of law all speaking roughly to the same issue: the state law, the charter provision, and the way we have implemented it through the code. The code and the state law now sync up very well. There is a little bit of a mismatch in the charter, but I think the code can hew closely to the state law because we're required to do that, and also the code can be in some ways more restrictive than the charter is, which goes beyond what the charter says violate. So that's my best answer to that. We spoke through all of these. All right, so what? What happens if a board or an assembly violates the Open Meetings Act? What is the big deal? We were happy to report to the school board members that individuals don't get named in an Open Meetings Act lawsuit. There's no financial consequence to anyone. Nobody goes to Open Meetings Act jail. But Open Meetings Act violations can be the basis of a recall petition. And in Anchorage, they have been. I believe I think there's only one occasion in Anchorage where people have actually been recalled from office. And Walter Featherly Featherly and two other individuals who'll be on the next page were on the school board at some very contentious time in the early 90s.
Paul Featherly, Carol Stolpe, Madam Chair,
Thank you, Mr.
and
Chairman.
Deborah Cox.
another lady,
You want to send it?
school board members.
Mr.
And-
Clausen? Thank you. Before you go on, I want to make a comment too, okay? There was another situation when I was staff in the assembly where 7 assembly members had an ethics charge brought against them and accused them of open meeting act violation. So that's just an example of something that happened with Tess. And it's one of the reasons why I'm so careful in terms of how I handle myself when it comes to emails and replying to all. And we'll talk more about that a little bit later. Mr. Training.
Other was Dorothy Cox. She was another one that we called.
When I click the slide next, you will be proven 100% correct. Through the chair, that is right. The Board of Ethics under our own code is supposed to be able to adjudicate whether an Open Meetings Act violation has happened. I'm actually not entirely certain what the consequence for the individual would be, but we did certainly look into that. I don't know if that, in my recent time.
Well, if I can follow up, the consequences in this particular situation was they were all found innocent.
Yes.
So, thank you, Mr. Paulson.
Yeah, and I will say that is a little appreciated part of our code because the provision that says our Board of Ethics is supposed to opine on that is not located in the ethics code. It's located elsewhere in an open meeting section. But in any event,
One moment, please, Ms. Ennis. There is a recent Board of Ethics decision that addresses all these issues.
Thank you,
Just
Mr.
this administration.
Please continue, Mr. Paulson.
I will say one other thing about these recall petitions, which is more potentially unwelcome news. The grounds for recall set forth in the petition are what is submitted to the municipality by the person asking for the recall, and there is no ability for the municipality to ground truth any of that. So we have to take that and put it on the ballot, and then each person who was subject to the recall actually was able to write a statement that appeared on the ballot underneath it that said, "This is all false. There's no truth to any of this." But as it turned out, every single one of them were recalled. And the only real sieve that we have when reviewing the recall petitions is whether taking the facts as alleged would be a violation of law. And if someone says, you guys violated the Open Meetings Act, we would be in a pretty tough space to do anything other than to say, that goes to the voters, and then you, like Walter Featherly, Diane, Carol Stolpe, and Dorothy Cox could all say, not true, not true, and it would be for the voters to decide. I think 1992 was a particularly hairy time where the superintendent was getting fired, and probably had nothing to do with Open Meetings Act violations, but just general distaste for the school board. I don't know that one way or the other.
Mr. Dio?
Do you continue to do your job, while you're waiting for that ballot measure to go out and get voted on?
You do. I think you're not recalled until the certification of the election, so you're in the seat until you're not.
Thank you, Mr. Steele.
Through the chair. It just maybe of interest on that, and I used to work for the North Slope Borough, but they, you'll recall, just recently recalled the mayor. And she worked right up until the day of the recall election. And then the other interesting wrinkle was, whoever the borough attorney was decided, I think through the clerk's office, that she could run for office again, even though she'd been recalled. She got 40 votes, I think, but.
That's right.
But her brother-in-law's in the office.
Yes. Interesting.
Small world, small world. So what? So we've said that there may be Board of Ethics consequences, which was a very good point that I should have rolled into this presentation, but you wouldn't be named individually in a lawsuit, but you could be the subject of a recall petition. But there's also consequences for the assembly as a whole. So board actions that you take in violation of the Open Meetings Act are voidable. They're not automatically, immediately voided. It's not like it never occurred, but they could be invalidated by a court. And that is the perhaps most baroque part of the staple piece of paper that I've given you. If someone alleges that the Assembly took an action in violation of the Open Meetings Act, within 180 days, so half a year, they can bring an action in court to say, I want that resolution that you passed in violation of the Open Meetings Act, or that ordinance, to be invalidated. The Assembly can then cure the defect by basically holding a do-over, just declaring a mulligan. We're gonna have another meeting, and it's gonna be properly noticed, and we're gonna show the public all of our deliberations before we take the exact same action, and that will generally cure the problem. But it has to be real. You have to have a substantial public reconsideration of the matters considered at the original meeting. If that doesn't happen, or it can't happen, then the court is invited to apply this balancing test, and the court can void the action if the public interest in compliance with the Open Meeting Act outweighs the harm that would be caused to the public interest and to the public entity by voiding the action. There's a lot of ways this could go, but I think the punchline for this audience in this setting is we can avoid all this by just complying with the Open Meetings Act, and so it's better not to be anywhere near this world. And that is the fourth of our 5 scenarios, the executive session. Our final scenario takes us to our last ring of the circus, and it is the serial conversation, which I think probably gets the most interest and attention. Here's our scenario. Assembly members have one-on-one conversations in which they discuss pending legislation, discuss their own preferences, solicit each other's advice. They have this back email conversation, go to the meeting, and it passes with very little comment. Does this deserve our cheers? Or you know the answer is no. And this serial meeting question has gotten a lot of attention, and the most definitive word on it is not even really that definitive, but the Supreme Court of Alaska in Pickle versus Southeast Conference, which was a redistricting case, reviewed allegations that members of a redistricting board had substantive conversations not at the publicly noticed redistricting meetings, but offline serially with each other, even though there was never a majority of them in one place and never 4 of them in one place. It was a game of telephone. And the Superior Court, the lower court in that case, said that's a violation of the Open Meetings Act, and the Supreme Court affirmed that. And so they stepped into it by saying, a meeting is supposed to include every step of the deliberative and decision-making process. And the question is not really, do you focus closely on whether there was at any time a quorum of people who were violating the act, but whether, the question is not whether a quorum of the government unit was present, but whether the activities of the public officials have the effect of circumventing the Open Meetings Act. And in this case, the Superior Court had found that had one-on-one conversations with each other in which they discussed reapportionment affairs and redistricting preferences, they asked each other for advice, and then they had the actual meeting, and there was a total dearth of substantive discussion on the record, combined with the way they handled themselves, et cetera, and the court said, so we agree, the Superior Court, we agree with the finding that the redistricting board violated the Open Meetings Act. This somewhat remains an open question. There are still people who think, well, maybe the court got this wrong because hewing closely to the black letter, the Open Meetings Act shouldn't apply unless you really do get this quorum, but I think the court has made it pretty clear that they're going to be guided by those first policy positions that we presented for you in the first slide. The people are supposed to see all the deliberations. If you're hiding the deliberations, even in a way which would comply with the black letter law of the Open Meetings Act, that's going to be stretched into an Open Meetings Act violation. And then you're off into that mulligan, redo the notice, or potentially void the action again. That is the serial
Mr.
conversation.
Houston.
Thank you, Madam Chair. So, you know, if a person is, assembly member's working on an amendment, and you obviously need a second on the amendment before you can actually have a public discussion of the amendment, would it can't be a violation, contact one of the other members to see if they'll second your amendment, is that correct?
Through the chair, I think that has gotten to be true. The courts have never had to really look into that. But my counsel in that circumstance would be, there's got to be a way for assembly members, less than 4 of them, to get together, to talk about what they want to do, to craft some legislation, to introduce things, to jointly present an amendment. And I think that only becomes problematic if there's a lot of discussion that happens that never sees the light of day. And it will get messy if ever this were forced into a court. But I think what I would counsel is, the safest thing you could do is, after having the internal offline huddle, to re-air the substantive part of that huddle when the actual meeting occurs. So, and I've seen the assembly do that. So when we've had the work sessions, we say, this is a joint amendment being introduced by Assembly Members Dunbar and Weddleton. If you then effectively take the curing steps that you would be allowed to take under the Open Meetings Act anyway, say we had this meeting, we bet around some ideas, this is what we landed on, this is why we like it, then I think the public has seen the deliberations in a way that I at least would be comfortable defending any of you saying that it's consistent with the Open Meetings Act.
Thank you,
All right, thanks.
Mr. Cheney.
Thank you, Madam Chair. Mr. Peterson, in the past, for example, it takes 3 years to do this. So you come up with an ordinance and get with 2 of your Assembly colleagues, and the 3 of you agree to introduce it. And that doesn't violate the Open Meetings Act. What you don't want to do is get a 4th one. Then you've got a problem. Because our charter requires you to have 3 of your dues.
Right.
So.
Thank you, Mr.
that
Cheney.
works for us.
Mr. Dunbar.
Did you have something you wanted to say first?
Oh, I was just gonna add to that, remember in the first part of this, you talked about the subordinate unit of 2. So in the rare instance that you were, I would say, avoid going to that other member for your second, if it's that subordinate unit of 2. The other thing I was gonna mention, just to underline how big an area of law this is, we've got a 2-volume treatise on open meetings law across the country. 30 pages are devoted to just this issue because it can happen by text, by phone, by email, in conversation. So, and some states have very specific laws about it. We don't. We've got the single case law. But it is an area that can trip people up because, well, as Mr. Dunbar mentioned and Peterson knows, in the state legislature where it doesn't apply, it's kind of wheeling and dealing happens all the time.
Right. If this applied to the state legislature, it would ground. So, Madam Chair, good question. So, what's that? Yeah. Well, fair enough. So you would just describe a scenario in which there was a discussion at a work session and it was all re-aired at the meeting. But I was under the impression that our work sessions are already sufficient because they're noticed. Is that correct? And I guess a follow-up to that is, and this is something I've just been sort of thinking about, and this is as good a place as any to ask about. It seems like we're often in these different meetings, and the comment is made that we're not debating at this time. Like we're not, and I know we're not supposed to debate with the public, but when is the time when we really are supposed to get together and have the long-form debate about the substance of a policy that is introduced to us by the mayor? Is that at the work session, or do we want to extend our meetings? Is it all supposed to be at the main meeting on Tuesday? And I guess this is a question for you, Alvy and Dick, as much as it is for
Okay,
Bill.
I'll let Mr. Cheney go first, and then I'll make some comments.
Just
and then-
the work sessions are the time for us to work on the legislation. You can't take a vote on, for example, I wanna take this section, I wanna add this section, but you can tell us your point of view on it. I want to do one of the things that goes to the chair. We've disciplined our own in the past. We had a Assembly member years ago that committed a crime. We knew he had done it. And we told him, if you don't resign, we'll remove you from office. He resigned. Because he knew he was guilty, we knew he was guilty. We disciplined our own. So beyond the Open Meetings Act, we can enforce our own discipline on the body.
So let me ask, the debate, the decision to expel that member or ask him to resign, where did you conduct that debate and discussion?
That was among 2 of us, the chairman and the vice chairman. We presented the evidence to him. He resigned rather than go through what would have been an ugly meeting.
Thank you, Mr. Cheney, and if I can follow up, and Mr. Folsey, if you don't agree with me, that's just too bad. Just kidding. But anyway, here's how I see it. Work sessions, or just that, work sessions for the Assembly members to discuss usually legislation that we're going to act on at our upcoming meeting, okay? And the work session is like Mr. Cheney said, we can't vote because it's a work session, it's not on the floor. During a public hearing, I'll use that for an example. Once a public hearing closes, that is the body's opportunity to debate, if you will, make comments, talk about why they support
was just saying, I've seen committee meetings where there's actually quite a bit of give and take as a recommended ordinance, which would then go to the full assembly. And sometimes Title 21 committee had, I think, 4 or 5 assembly members on there, and there's a lot of give and take, and it's not a formal vote, but it's consensus building.
Right, and if I can follow up before you tell me, Mr. Flossie, at committee meetings, often there's legislation that is forwarded to a committee, and the reason why it's forwarded to a committee is to give the committees, yay or nay, if you will. And so often at committee meetings, and I don't see an issue with that, we'll make a recommendation. We don't necessarily call it a vote, but we'll make a recommendation. And Mr. Evans and Mr. Trainee will remember when we were dealing with the marijuana sales tax issue, our Budget and Finance Committee, before it was a committee of the whole, made a recommendation, as far as whether it was gonna be under, the tax cap or above the tax cap. And there was one member who didn't agree, and when I gave my committee report at the Senate meeting, I, relayed that message to Assembly members. Thank you. Mr. Flossie.
So, Mr. Devar had asked, for clarification on the curative, arrangement that I suggested, where if you have offline meetings, you can then openly discuss sort of the content of the deliberation. My scenario was that somewhere in a Kaladi Brothers or something, a couple assembly members had gotten together to come up with an amendment, and then at the work session, we would do the airing. So I think that was the same scenario that you had in mind. It's maybe not written in stone, but the best that I can offer, which is to keep as much of the deliberation in the public eye as possible, and it's going to keep you out of trouble. On the specific question of where the debate is supposed to happen, I think that's more a matter of practice than a matter of law. The code says a work session is supposed to be a place where information is obtained and the issue is discussed. A regular session is where the debate, where the action of the body occurs. In some ways, it will be up to the chair of either the assembly or the subcommittee to regulate how the conduct of that debate discussion will occur. But otherwise, I have nothing to dissent from the comments that the vice chair and chair.
Thank you, please.
That brings me to the end of my prepared remarks. I'm happy to answer questions. And if there's anything else that either Todd Sherwood or Deanna would like to add, I'll solicit their involvement as well.
Well, I was just gonna add to what the chair said about, subcommittees and work sessions. And there is a lot of discussion that goes on, but I can say from department perspective, I think it's the kind of head nod of go in this direction or don't go in this direction is helpful, because we're often bringing back the next iteration of maybe like in the marijuana regulations and that kind of thing. So, and that's never been a problem, because it's very open, it's very public, it's not a formal vote. And there's always an opportunity for it to change in front of the full assembly.
Thank you, Mr. Sherwood. I would like to talk a little bit more about, emails and the reply all function and serial meetings, because the reference that I mentioned earlier, they were accused of having serial meetings. So, Mr. Paulson, I'd like to hear your opinion on the reply all function, because I don't do it. When I respond to a constituent email, I don't need to let the rest of my colleagues know that I'm responding, number one. Number two, I don't wanna ever be in a position where I'm accused of a serial meeting, because it's too, you just never know how things are gonna work. And we have one assembly member send a message, an email to all of us, and, that particular assembly member felt that it was just fine. And I personally didn't agree, but I'm not anybody's mommy, by no means. I just want us to do what we need to do, on behalf of the citizens that we serve in this community, and not get ourselves in trouble, frankly. And so I would like for you to talk a little bit, and also our attorney, if she would like, about the reply all function and email. Thank you.
Yeah, and I think my advice and counsel is largely in line with that position. I think there's got to be a mechanism for the assembly to say, I intend to produce this amendment. That to me does not seem like an uncurable meeting act violation, because when the work session occurs, when the assembly meets, that amendment will be produced, no harm, no foul. I think it is a different scenario if the assembly member says, I intend to produce this amendment, and beyond the face of what I've written in the document itself. Here is 7 reasons why I think it's a great idea. Nobody replied to me, but I've got the following people who also support me, et cetera. And if that never shows up anywhere again, then I think that is a substantive part of the deliberation that got lost. The people who did not succeed their sovereignty over the instruments they created would never have seen it. So then you really are exposing yourself to some open meetings act risk. Whether that comes to fruition in a real court-ordered violation or not, I couldn't say definitively, but it also seems like a risk you don't have to put on your own shoulders. So the better course is probably to
Thank
avoid
you.
it.
Mr. Peterson first, and Mr. Dunbar.
Thank you, Madam Chair. And so the proper way to do that is, instead of sending an email to all Mass Assembly members about something you want to introduce or whatever, an amendment or whatever it is, you send it to the clerk, and then the clerk distributes it. That is the proper procedure. Is that correct?
That's the procedure we've been following, yes.
That's the procedure that we've been following, and I think that's entirely fine too. And like I say, that scenario is easy because the only piece of information that you're forwarding to everyone offline, outside of the public notice meeting, shows up exactly, precisely the exact same form at the meeting. So
Right.
there's really no uncurable violation.
Right.
Thank you, Mr. Peterson. Mr. Dunbar, and then I have a comment. Mr. Dunbar.
But I just want to say that what you just said is I didn't realize. So if you send a message to the clerk and send everyone, it's then published somewhere in our when we go to the full meeting. Is that what you just said?
What I was imagining is when the assembly member, the individual assembly member says, I intend to introduce this amendment, please have copies at that meeting.
Oh.
I don't know what the practice is.
So sometimes we have, for example, questions sent to the clerk that are then distributed to everyone. Are those later publicly distributed?
Those are, if I may, those are questions that the clerk forwards to the administration.
So is there always administration, not to other
No,
members of the body?
well, no, not the public, just the administration, because they're the ones who are going to answer the question.
Right.
Now, when it comes to amendments,
Right. You never-
yeah, the clerk, the amendments go to the clerk, and then they're published so that the public can see. You want to continue?
Well, there's one other question based on what you had just said. So I understand when we send an email to other members of the body with the reply all function, we're soliciting debate or discussion, or we're expressing our own views. But something you had said about constituents that write in and not seeing the reply all. I guess I sort of feel the opposite. I haven't done it yet. But I like seeing when one of the other members of the body responds to a constituent. And to me, it doesn't seem to violate the spirit of the law. And I'd like to hear Bill's opinion on this. Because we're not engaged in internal deliberation, but we're seeing the way in which a member of our body is relating to another member of the public. And I think it helps us inform our own decision to reach out to that person, or to sort of set things like tone, or to address a different part of the overall argument with that constituent. And so to me, it doesn't seem to violate the spirit, at least, of the law. But perhaps you have a different interpretation of it.
I'm sorry, I didn't mean to interrupt you, but before you comment, I'd like to follow up. Okay, thank you.
Sure.
All right, here's how I see it, okay? The majority of our emails are sent to all of us,
Yep.
okay? If there is an email that is district specific, I still respond, because I like being responded to. And I simply say, dear so-and-so, thank you for writing, your representatives are so-and-so, and this is, and I'm sure that they'll be contacting you. I don't really need to know that we responded to the email, Bill responded, I don't need to know that. And furthermore, our constituents, because we get emails back, they write stuff like, oh, well, it was so great that I heard from 4 assembly members, okay? But I don't need to know what you have to say, I don't even need to know they responded, because in my opinion, if they're talking about Title 15, okay, or something that we're dealing with, which is probably the majority of the time what folks are writing to us about, we can get ourselves in trouble if we hit that reply all button, because it's something that we're gonna be dealing with on the floor, and we have this back and forth, conversation, that's, in my opinion, is quite dangerous. Mr. Falsey, please.
I think, again, I just say, I agree. The scenario to have in mind would be what happens when it shows up on the front page of the paper, or as Exhibit A to the complaint that's filed in the court. And if it is just kind of innocent, thanks for the email, that would be one thing. But if the assembly ends up passing take your pick, noise complaint ordinance, and it comes to find out later that never discussed in any work session or at the actual assembly, there was a whole offline discussion where 3 people, Moose's Tooth, the Bear Tooth, some other outdoor vendors are having a whole offline discussion about what the noise ordinance should be consisting of, and all the assembly members were involved in that conversation. Then it really does look like, oh, there was this whole other process that took place that was not the process that was the process that led to the law, but no one knew that was even going on. So I think it's easier to not reply all. Probably there's not a lot of upside to the reply all.
Right, thank you, Mr. Evans.
Yeah, just following up on that, I mean, the recent instance when I replied to all responding to that one constituent, was more a rare situation where there really was no substance to the constituent's complaint. He was just angry about something, so I didn't think it was I didn't think we got to an area where it could be something we were acting on, because I didn't even know what he was talking about really as far as substance. But yes, he was responding about a particular issue that was before us that he was upset about. It probably applied all for the reasons stated.
Thank you, Mr. Evans.
And I should also say that in some ways, like almost all of these legal rules, it comes with an invitation for you to consider what your own risk tolerance is. Safest course would be to wear a padded suit, never see any of these people anywhere outside of a publicly noticed meeting, keep your head down, get a little low jack on everybody so if the beeper goes off and too many are close. That's not realistic, that's not gonna be the real world scenario. So it's just, be aware what the rules of the road are. I would counsel you to stay away from the line, but you can get close to the line, but the line is fuzzy, and that's part of the.
Thank you, Mr. Sherwood.
Madam Chair, because this is sort of a corollary matter, but the corollary of this open meetings is public records. And since we're talking about email, and I'm kind of the public records guy in our office, I just wanted to say, my recommendation is you use your work email for work. I know some people like to use personal email, and 2 major public examples, of course, were Sarah Palin and Hillary Clinton, and the problems that can create, because it doesn't matter if you're using your Hotmail account or you got your own server, that is still going to be a public record. What it does is significantly complicates searches when they need to be done. And this happened in 8037, public records request was just massive. But if you're going to use personal email for some reason, for work related, then always copy your work account at a minimum, because IT can't and won't go in and search your personal Hotmail account. And then, there may be issues about public trust, that kind of thing, but again, as Sarah Palin and Hillary Clinton found out, it's still definitely public records. Just the fact that it's in your personal account doesn't take it away from that.
Thank you, Mr. Sherwood. Ms. Tucker.
I wanted to follow up on Bill's comment about personal risk, and to give some kind of also context and shared background with some of these members who've been on the longest. It's not only your risk and your tolerance level, but when you do the reply all, then you're engaging other assembly members in a risk tolerance that they may not be comfortable with. And so the 2 examples that we had in the past, one assembly member used the constituent email to engage in the debate in this manner. That assembly member would write back a pretty argumentative thing to the response to the constituent, and then forward it to the assembly members and say, here's what I wrote to so-and-so, what do you think? And so then you have all this crosstalk back and forth and this huge bubble that, on something that was obviously in front of the assembly. The other example was an assembly member who had particular constituents that assembly member would become very annoyed by. And so the constituent, the assembly member viewed some of these constituents as, when they came for testimony or public appearance requests, as wagging their finger at the assembly. And the this particular issue that the constituent was complaining about. So you gotta think about that when you're doing it, that your tolerance level for taking on that Open Meetings Act may not be shared by some of the people who are included in your reply all of us.
Thank you, Mr. Tucker. I'd like to, for the record, recognize that Mr. Flynn has joined us. Mr. Evans?
And just briefly on the overall, being most scrupulous about this, that's why it's important if we have meetings with one other assembly member on any topic, we let that assembly member know who else we may have talked to. Because otherwise, I may talk to Forrest, but I didn't tell Forrest, I already talked to John about it, and then we inadvertently kind of create that chain, so is there a requirement?
Thank you, Mr. Evans. Mr. Peterson?
Well, thank you, Madam Chair, and I actually have my work email and my personal email, but I've had my personal email for so long, I've got so many people that have that email, that a lot of times they're asking me, job-related, assembly-related questions on my personal email. And then, but sometimes I've met constituents, and they don't really separate the personal stuff from the work stuff, from the political stuff. And so sometimes, I've had a couple times, people will send me emails that are politically motivated or about politics on my work email, and I'll send them back an email, say, thanks for your email, but I'd appreciate it if you would send those type of questions about that type of subject to my personal email. So, it's the constituents out there, it's hard for them to know where the line of, politics and assembly business, intersect or don't intersect. And so sometimes you have to kind of steer them in the right direction.
Thank you, Mr. Peterson. Just one comment before I go to you, John. I agree with you. What I do when I get an email on my personal email, I forward it to my muni email before I respond, and then they get it. Oftentimes, I don't know if anybody else has experienced it, but I get Facebook messages that's constituent business, and I write them back and I say, I do not do constituent business on
Facebook.
Here's my muni email address. Thank you, Mr. Peterson. Mr. Graveler?
On the thing, because I get emails to my personal account too, so forwarding response to the muni.org makes that stuff. If I delete something off that muni.org when I log in, is that, say, you still have records of that? So is it okay for me to delete stuff because they all get clogged up, or should I not delete stuff and leave it all?
That's the problem.
Just send everything.
Because from having talked to, I'm sorry, through the chair, from having talked to IT, there isn't really a big backup system that collects everything. So if you delete something in your Muni email box and then you delete your deletes, it's essentially gone forever. Now, that being said, and this is one of the issues that comes up is, and there's no hard answer, what is a public record? What is a public document? It has to do with how government is run. So if there's a constituent who says, I want to meet you for coffee to discuss X, I don't think it's a big deal to delete that email because it's not substantive. On the other hand, if there's a series of emails back and forth and it's very substantive in nature, then that's probably the kind of thing that it should be kept. And how long you keep it, there's a records guide that works for IT that has, for all the various departments, how long different kinds of things are supposed to be kept. But there is no neat little system that backs that all up. So it's ultimately a judgment call, which is a terrible lawyer answer to give.
But we also don't have unlimited storage space.
No, we don't. And when I worked for the North Slope Borough, but see, that was 10 years ago, they were basically backing up everything. If you deleted something right away and didn't catch that, it was like a 24-hour system. But yeah, there is such a mass now of electronic information, you can't possibly keep it all.
Thank you, Mr. Sherwood. Anything else, Mr. Wilson?
The only final thought I'll give is on this public records item. From our perspective, it will help us if we ever end up in a court situation to say what we advised you all was to do public business on a public system because that's the only system that we can search so that we can tell the court we can apply with all of our discovery obligations. We ran the IT searches that we are capable of running. From official account, because if ever you got a subpoena that said, I need you to produce all the emails from your Gmail account, you might be able to respond with an affidavit that said there are no responsive emails that have not already been produced through the municipality, because I made it my practice to constantly CC and hopefully get out of an individual discovering them.
Thank you, Mr. Pelosi. Any other comments before we adjourn? This was a really worthwhile, work session. I'm glad to see so many of my colleagues here, so thank you for being here today. Was it Ms. Tucker? Nobody
Oh,
wanted over
thank you.
here.
I
Briefly, please, thank you.
Does the municipal public records, code differ substantially from the open meetings that got even, I mean, on the,
The state public records act.
yeah.
So through the chair, I wouldn't say it differs substantially. It does differ in some ways. One particular way is, you know, we have the Alaska statutes, and then they have the Alaska Administrative Code, which is regulations that further interpret. Those, for the most part, do not apply to us. But it lines up fairly close on that sort of thing.
Thank you, Mr. Chair. Ms.